Welcome to our September 2023 edition of This Month in Payroll. I'm Rowan Geddes, National Leader of PwC's Payroll Advisory and Operations Practice, and it has been a big month with the release of the Closing Loopholes legislation, the latest instalment in this government's industrial relations reform package. In this special edition, we will explore the new legislation, considering what it means for payroll. We will also touch on some of the other changes that affect workforces more broadly. This month, the government introduced into Parliament its latest round of industrial relations reform, the Closing Loopholes Bill. The bill came in at 284 pages long, covering amendments on a broad range of workplace relations matters, as well as areas such as work health and safety, small business redundancies, family and domestic violence protections, and workers' compensation. So what is in the bill from a payroll perspective? We want to highlight three key proposed changes. First, increased wage theft penalties, including criminalisation. While the criminalisation of wage theft is the change that captured headlines, it is important to note that wage theft will only become a criminal offence if the employer is proven to have intentionally engaged in actions that resulted in depriving employees of their wages. In discussing the bill, the Minister for Employment and Workplace Relations, Tony Burke, made it clear that underpayments that are accidental, inadvertent, or based on a genuine mistake would not be criminal. However, while criminal penalties should not be relevant to our listeners, the proposed change to significantly increase civil penalties for wage theft are. The proposed changes include 1. The standard maximum civil penalty that would apply to a single contravention of the National Employment Standards, a modern award, or an enterprise agreement would increase fivefold to $469,500 for a corporation and $93,900 for an individual. Second, if the contravention involves an underpayment, that maximum penalty can be increased to the greater of 5 times the otherwise applicable maximum civil penalty, or 3 times the underpayment amount. And finally, if the underpayment relates to a serious contravention, this will trigger higher maximum penalties again, of up to $4.695 million for a corporation. Importantly, the definition of serious contravention, which used to be limited to situations where the employer knowingly underpaid an employee, has been changed and now includes situations where the employer was reckless as to whether a contravention would occur. Recklessness involves the awareness of substantial and unacceptable risk of the contravention occurring. A question that has arisen is whether the new penalty regime would apply to wage remediation programs that are already in train. The draft legislation includes a transitional clause, which makes it clear that the new offence for wage theft would apply prospectively, that is, in relation to conduct that occurs after commencement. Change to the definition of casual employment. Another key area of focus in the Closing Loopholes Bill is the treatment of casual employees, and the government's concern that casual employees suffer from the lack of access to secure employment. 2 years ago, in response to cases such as Workpac versus Rosato, around the treatment of long-standing casuals, the former government included a definition of casual employee in the Fair Work Act, which stated that a person's status as a casual employee should be assessed on the basis of their offer of employment, not on any subsequent conduct of the parties to the contract. The Closing Loopholes Bill reintroduces the previously understood definition of a casual employment relationship as being one categorised by the absence of a firm advance commitment to hours. In addition, the bill introduces a second limb. To be a casual employment relationship, the employee must be entitled to a casual loading under the terms of a Fair Work instrument or contract of employment. This also means that the casual loading that is paid must be identifiable. The reinstatement of the absence of a firm advance commitment test requires employers to consider the following questions. Is there a mutual understanding or expectation between the employer and the employee? Can the employee elect to accept or reject work? What is the future availability of continuing work? Are there employees performing the same work who are part-time or full-time employees? And is there a regular pattern of work? The proposed law also introduces a new pathway, employee choice, for casual employees to transition to permanent. This is in addition to the current casual conversion process. Under employee choice, an employee who has worked as a casual employee for more than 6 months, 12 months for small businesses, will be able to notify their employer at any time that they believe they no longer meet the definition of a casual employee. If the employer accepts the employee choice notification, the employee would transition to permanent employment from a date specified by the employer in consultation with the employee. The grounds that an employer has to reject an employee choice notification are more limited than under casual conversion and include only 1. The employer believes the employee is still correctly classified as a casual employee, or 2, it would be impractical for the employer to accept the notification because it would significantly affect the way the employee would need to work, or 3, a change of employment status to full-time or part-time employment would not comply with the recruitment process required by a law of the Commonwealth, state or territory. The proposed law also contains a range of anti-avoidance provisions and offences similar to sham contracting, preventing employers from manipulating an employee's pattern of work to avoid rights to casual conversion or misrepresenting employment as casual employment. The Closing Loopholes Bill will also introduce a requirement to provide a casual employment information statement to casual employees after 12 months of employment, in addition to when the employment commences. These laws have a proposed start date of 1 July 2024. If passed as drafted, employers will need to go back to reviewing their casual employment arrangements to identify any relationship that may actually be viewed as permanent rather than as casual, as well as considering the process for responding to employee requests to convert from casual to permanent. Thirdly, removal of certainty around contractors. A third area of focus relates to the long-standing contractor versus employee dilemma. Over the last few years, through cases such as personal contracting and JAMSEC, the High Court has provided a welcome level of certainty for employers by focusing primarily on the wording of a contract when determining whether a worker is an employee or a contractor. This bill removes that certainty by creating a legislative version of the old common law definition of employee. This definition considers the totality of the relationship between the parties, bringing back a substance over form test where a regulator and the courts are asked to consider not only the terms of a contract, but also the performance of the contract over its duration. Pre-JAMSEC, this interpretation resulted in situations where workers were able to consider what their actual role had been over a period of time and subsequently seek a reassessment of their agreed classification as a contractor. If this change goes through, employers will no longer be able to set and forget their treatment of each contractor. Rather, they will need to continually assess the roles of these workers or risk being exposed to back pay claims for employment entitlements such as termination benefits and unfair dismissal. The proposed rules add a further complexity for employers in that the new definitions of employees would only apply for the purpose of the Fair Work Act, not other laws relating to employment benefits such as superannuation, which is governed by the Tax Office, or long service leave, where the common law from the High Court decisions would continue to apply. This will create a significant risk of confusion for the employer and the worker, and in practice could result in employers applying the broader definition of employment across all jurisdictions, which in turn could cause an overpayment of employment benefits. These changes reflect some of the most relevant for payroll. However, there are more changes involved in the Closing Loopholes Bill which will affect workforces, including gig workers. Under the bill, an additional employee-like category for digital platform gig workers will be introduced, and the Fair Work Commission will be empowered to set minimum standards for these employee-like gig workers, including minimum pay and unfair deactivations. However, the tribunal will not set minimum standards on terms such as overtime rates, rostering arrangements, or terms that would change how a worker is engaged. These new rules will not apply to all gig workers. Rather, a worker will only be employee-like if they are in a position with low bargaining power, or have low control over their work, or receive remuneration at or below the rate of an employee performing comparable work. These exceptions are expected to ensure that the new regime covers platform workers like food delivery drivers, rideshare drivers, and care sector workers, but excludes work gained through bidding on platforms like Facebook or Airtasker. Similar changes will also be applied to road transport workers, in that the Fair Work Commission will be provided the ability to define minimum standards and introduce collective agreements applicable to owner drivers. In addition, an expert panel will be authorised for the road transport industry to improve job security and to set fair minimum standards, including fair payment times, and to hear cases of unfair termination of contracts. Labour hire workers are also affected by the Closing Loopholes Bill, which proposes amendments to the Fair Work Act to enable employees, unions and host employers to apply to the FWC for an order that labour hire employees must be paid at least what they would receive under a host's enterprise agreement or equivalent determination. The application is limited to arrangements that are only for the supply of labour rather than services, and will not apply where employees are working for a host business under a training arrangement, or where the host is a small business employer employing fewer than 15 employees. In addition, there is a 3-month exemption period proposed to minimise the impact on arrangements for surge work or where there is a short-term replacement worker that is needed. The next steps. Noting the complex issues included in the bill and the need to engage in wide-ranging consultation with multiple stakeholders, the Senate has referred the bill to its Education and Employment Legislation Committee. Submissions are now being called for in relation to the proposed bill, which are due to be submitted by the 29th of September. The committee has then set a reporting date of the 1st of February of next year to come back with its recommendations, after which time the bill will be retabled for debate and, if passed, enactment. We anticipate a flurry of activity on both sides of the argument over the next 5 months, and we will continue to report on developments in this space up to the release of the Senate Committee's recommendations on the 1st of February next year. And that's it for this month in payroll. If you'd like to revisit any of our prior updates, they are available on our website at pwc.com.au/payroll. And if you have any questions or need for support, please reach out to myself or your usual PwC contact. Until next time, have a great month in payroll.